This is a great summary of what happened on Monday. So y'all enjoy this one. Real quick, Kurt, come on up here to the front of the church. Let's go.
Candace Owens is getting sued for defamation by the president of France and separately by the man who ran security for Charlie Kirk. For over a year, she's told her audience that she wants this. Bring on the discovery. Bring on those subpoenas. But Monday morning, her lawyer stood up in a Delaware courtroom and spent the entire hearing trying to kill both cases before discovery ever started. And the argument they picked? Delaware has no business touching her. Delaware, the state she personally sued someone in. Let's get uncivil about it. So Monday, July the 27th at 10 a.m., Judge Renee took the bench. And for the next couple of hours, two very expensive lawyers explain why a French head of state and a private security contractor from Texas should both go home.
All right, let's talk about what actually happened in Delaware today. This is not rumor, and it is not recycled internet chatter.
Well, that much is true. It's definitely on the docket, so let's talk about it. So there are two cases in play here. Case one is Delaware.
The Macrones filed a 22-count defamation and false light lawsuit in Delaware over Candace Owens' Becoming Brigitte series and related content. They allege Owens falsely told millions that Brigitte Macron was born male, that the Macrones were involved in identity theft and incest, that they were tied to MK Ultra-style mind control conspiracies, and even that they were connected to assassination plot rhetoric tied to Wilmington, Delaware.
22 counts. Now, that was filed July 2025 against Owens personally, plus Candace Owens LLC, plus George Tom Inc. The Marcons have said that the claims against them are fabricated. Owens says she's a journalist, like that's an answer to everything. Nobody, of course, has been found liable for anything yet, but we need to hold on to that thought because it will matter later. As for case two, Tennessee Federal Court. Nashville filed April the 30th.
Plaintiff Brian Harple hereby sues defendants Candace Owens and Mitch Snow for defamation and conspiracy to defame.
Brian Harple ran security for Charlie Kirk, and the story he says got told about him is not some mean tweet.
He said that he personally saw Brian Harple, again, the head of Charlie Kirk's security team, and Erica Kirk meeting with top military leaders there. He said he was 99% sure it was Erica Kirk and 100% sure that it was Brian Harple. And he alleged, and so did Candace, that they met to make the final plans to assassinate Charlie Kirk.
So listen to that again. Conspiracy to murder his own boss against a guy whose entire livelihood is being the person you trust with your life. Think about what that kind of accusation does to a man in this kind of business. Nobody will hire a bodyguard who is rumored to have helped kill the last guy. There's no version of that where he simply shrugs it off and goes back to work as normal on any Monday. His career is the collateral, and it was spent on a story that had one shaky source.
Is Brian Harple going to be able to get a job in security? Obviously not. And that is why Mitch Snow and Candace Owens are being sued.
Apparently, he was in Dallas that day, which would make it somewhat hard for him to be involved. And per the complaint, she actually had the flight data and knew that.
Even though Harple's travel records place him in Dallas, and Owens allegedly saw those records before promoting that theory. The complaint alleges that she continued anyway.
So it's all a bunch of allegations with not a finding to support it. That's her side to fight. Fine, fight it. In discovery, which brings us to the whole point of this particular video. Because here's what she said she was going to do.
When this lawsuit was first filed, Owens publicly presented herself as someone eager for full discovery. She told her audience she did not want the case dismissed, said discovery would be out of this world, claimed she welcomed subpoenas, and even said she would testify and push the case all the way.
Out of this world, she said, welcoming those subpoenas, pushing it all the way. What story is she telling now?
But guess what? She filed a motion to dismiss in this case. What do y'all think about that?
Well, that's absolutely no surprise, I guess. So what did her lawyers actually argue on Monday? Because it wasn't the truth of anything.
Owens attorney Chad M. Chandler ridiculed the lawsuit as legally meritless and as an assault on freedom of speech. However, almost none of the arguments
Hey, that's me.
even mention the case's merits.
And you need to pay attention.
Hey, shout out to Kurt. I didn't realize.
Almost none.
I didn't realize Kurt used my video. Shout out to Kurt. He's a good guy. I love him. I love him. He needs to give me that sign back there, the YouTube sign. That's what I need. Anyway, shout out to Kurt.
None of it touched the merits. Argument one is personal jurisdiction. Delaware can't reach her personally.
Attorney Catherine Mowry
Hey, that's
argued
me.
that even if Delaware does qualify as proper jurisdiction, Owens should be removed for lack of personal jurisdiction as she lives and works in Tennessee, not Delaware.
In plain English, courts can only haul you in front of it if you reach into that state on purpose. It's called minimum contacts. It prevents anyone from just being sued anywhere. The state that wants to judge you has to have some authority over you in some way. And that requires you to do something that's called purposeful availment. It requires active steps on your part to avail yourself of the state so that they have the authority to judge you. And the Marcon's answer is that she reached in with both hands because she chartered her companies in Delaware.
Yep.
Argument number two is a borrowing statute. Delaware gives you 2 years to sue for defamation. France gives you about 3 months. So her lawyers argued that Delaware should borrow France's clock and time bar the entire case. Now, I need to explain that a little bit because if I don't say what a borrowing statute actually is, that might sound a bit insane instead of merely being audacious. A borrowing statute stops you from shopping for a friendlier jurisdiction. If your claim really arose somewhere else, the court borrows the other place's clock to just prevent you from suing anywhere because you didn't preserve your rights. That is a real doctrine, and it's not made up. Okay, let's put it all together. So we have an American podcaster arguing to an American judge that French law should apply to protect her from the French. The irony here is somewhat thick, given everything we know about Candace Owens. Now, for their part, the judge didn't shrug it off. Per the reporting, the judge said it plainly. If it's France, it's a wrap. So let me try to make her best argument because it does exist and it's not nothing. A sitting foreign head of state walked into an American courtroom over Americans' speech. Now,
Right.
that should make every one of us at least a little bit itchy. Congress passed a whole statute about foreign libel judgments for exactly that reason. Freedom of speech means something here, even if it doesn't mean things in other countries. And filing a motion to dismiss is not a confession. It's what competent counsel does. If your lawyer never raises a jurisdictional defense when there is one, you probably should fire that lawyer. However, here's where it begins to collapse. The statute blocks foreign judgments from being imported here. Now, Markin didn't import a judgment. There was no ruling in France that he's trying to have executed in America.
Correct.
Instead, he came to Delaware to file his lawsuit, and he took on our rules, including the ones where, as public figures, the Marcons have to prove actual malice. And that is the harshest standard in American defamation law. And the Marcons volunteered for it. That is somewhat the opposite of forum shopping. And the "my lawyers made me" defense dies on contact because she didn't say, "I'll let counsel do counsel things." She told millions of people she didn't want it dismissed. Which brings us all back to Delaware. And this is the part where, if it didn't before, it all gets a little bit stupid. In 2020, Candace Owens sued USA Today and a fact-checking outfit called Lead Stories. Where did she file that lawsuit? Delaware Superior Court. And under what name?
All right, Candace Owens in her individual capacity and Candace Owens LLC, a Delaware limited liability company.
Now, please take note of that. She sued in her individual capacity, not just the LLC hiding behind a filing
How do
cabinet.
y'all put up with
Her.
these silly ways I read stuff, man? How do y'all put
Personally.
up with me? It sounds hilarious when I'm hearing it. Like, wait, that sounds ridiculous. Why do I do that? What's going on? So I thought Kurt did an excellent job. By the way, Kurt from Uncivil Law, his link is down in the description. Please go check out his channel. He definitely is he's eccentric. I like him though. I really do like Kurt. He's a great guy. So definitely go check out what he's doing over there. Let's finish this up.
She lost appealed to the Delaware Supreme Court, lost again, and went knocking on the U.S. Supreme Court's door for all the good it did.
So it did seem kind of odd that in the midst of that, she chose to say that she shouldn't be sued from Delaware when she sued USA Today from Delaware.
And odd is a very generous word in this context. After all, Delaware's courts were good enough when she was the plaintiff. 6 years later, same person, same LLC, but now Delaware is apparently a foreign country.
And they are estimating $5 million. It's like a lot of money. And we do not have that money just laying around. So I thought we could actually sell some t-shirts. I just picture
there it
people
is.
wearing
There it
this,
is.
like,
There it is. Her selling the t-shirt. I asked about this video clip. Shout out. Where is this one? Which one is this one? I remember this. The irony of her saying she doesn't have $5 million wearing a big giant gold chain is crazy work. Now, granted, I know it's not a real gold chain, but you get the irony though. Let's go.
at the grocery store, like walking by each other, and like we know what it means, like hashtag free Emmanuel. And
T-shirts, $5 million. And the plan is t-shirts. Fun. So that's a good time as any to read that fine print, folks. The donation page said the company can spend your money on other corporate purposes. Other corporate purposes. In other words, they can do anything they want with your money, despite the fact that you thought you were donating it for a specific reason.
A total hypocrite. And this lady makes hundreds of thousands of dollars per episode, by the way, and wants you to help her with the defamation she did. She cannot take responsibility for her own actions, so she's having her audience do it.
And it's also worth noting that this is the same person who spent months telling you it was ghoulish for Charlie Kirk's widow to talk about merch numbers. Interesting how that doesn't apply when the shoe is on the other foot. Now, there is one line in particular from that Monday hearing that should scare her more than losing the motion outright. Her lawyers argued that the Marcons hadn't tied the companies to Owens tightly enough. You can't allege what's inside her companies because it's inside her companies. So the judge floats a very obvious fix. Open the door for jurisdictional discovery. And that would be wonderful to see. Ordered by the court to decide whether there is jurisdiction. Pretty typical procedural remedy. The motion built to stop discovery could be the very thing that produces the discovery, such as internal communications, revenue data, who booked the guest, who took the story, whether anyone checked the story. Delaware isn't even, however, the most dangerous case out there. In some ways, Tennessee is.
Harpel is a private figure. Harpel is not a public figure.
And here's why that one fact is worth more than the whole Delaware motion. Marcon is a head of state. He's obviously a public figure. So the Marcons have to clear the bar of actual malice. In other words, she knew it was false, or she blew past the truth with reckless disregard. Now, that's a pretty brutal standard, and most public figures lose right there. However, the security guard, Harpel, is a private citizen. He's not a public figure. He doesn't have to prove any of that at trial. He simply has to prove simple negligence, which is much easier. Negligence is the bar on the case where the complaint says flight records were already in her hands. And because accusing a man of conspiring in murder and professional unfitness at the exact job he does for money lands in a category called defamation per se, in order to make his threshold showing, he doesn't even have to itemize his damages. The harm is just automatically presumed as a matter of law. The law just assumes that you wrecked him. Easier case, worse facts, and it's the one that no one is really talking about right now. So where does that leave us? A woman who built an entire brand on saying the thing no one else will say is now betting her defense on the position that she cannot be asked anything, anywhere, by anybody. A private security contractor who spent 7 years guarding this movement got accused of helping the murder of the man he was guarding, and his answer was a jury demand instead of a podcast episode. And the invoice for all this is apparently being handed to the audience buying t-shirts. Let me be plain about why this one matters, because it does.
T-shirts is crazy.
The whole conservative case against legacy media for 30 years has been wrapped up in perhaps one sentence. You don't check for anything and you never pay for it. And that's a good argument, and it happens to be true. But it only works coming from people who check for things. The second our biggest platforms start running single source assassination stories and then hiding behind a jurisdiction motion, we hand every editor at every outlet we've ever criticized a permanent free pass and they'll use it forever. The First Amendment stops the government from jailing you from your opinions. In 250 years, it has never meant a private citizen can't haul you into court for lying about them. Being answerable to what comes out of your mouth is one of the most conservative ideas out there. We, after all, invented the lecture, and we gave it to everyone else. We don't have an exemption because the defendant has a good podcast and calls themselves a conservative. But 3 questions for you in the comment section. If discovery was going to vindicate her, why spend millions to stop it? 2, if Delaware courts were good enough when she was the plaintiff, what changed besides which chair she's sitting in? And 3rd, if the receipts are half as good as the merchandise, where are they? But tell me where you think I'm wrong in the comment section below. I'll read them and cover the ruling the day it drops. And don't forget to like, share, subscribe, and do all that great YouTube stuff. Until next time, I'm Uncivil Law. And remember to keep it uncivil out there. Cheers and goodbye.
Come on, man. Y'all put Kurt in the chat. I love Kurt, man. He's just Kurt, man. He is Kurt. I absolutely love Kurt. Thank you so much for tuning in to another episode of the JWhit Podcast. If you enjoyed today's show, please do me a favor and hit me up with that 3-piece special. Like the video, subscribe, and of course, share it with somebody who would also enjoy this type of content. And make sure you leave a comment because I do pin the best comments to the top. So thank you so much for tuning in today. And until next time, everybody, grace and peace.